Checkmate, or ignorance be gone. To have ignorance and make it leave, you have to read, not just copy and paste. So,
I'm about to give you two Supreme Court cases
that
that
right
prove that
there,
every
Rodriguez
code,
versus
statute, and
Donovan,
policy are not for.
Rodriguez versus Donovan, that is not a true citation, but you didn't even verify it. And what did you do? You posted that recently, 1 day ago. So, please, if you're going to try to do right by the people, at least verify your information. Now, one thing to point out about Cruden versus Neal that you posted, it is not a United States Supreme Court case. It is a Supreme Court of Law and Equity of North Carolina. So it does not apply federally, and it doesn't apply in every jurisdiction. Now, does it say what you quoted in your post, as in the one I pointed out on the bad citations? Yes, it actually does, but not in the opinion. The opinion is where you need to read the ruling of the court to see what they say. Okay? Now, for people asking, share the citation, you got to realize what you're asking. You see Executors versus Cruden v. Neal? That's called the name of a case. You see at the top where it says 2NC 338? That's the citation. Okay? When you see the, the little snippets of a case law, or things people call case law, what you're actually looking at is what they call the head notes. Okay? People should really, though, read the case. They should not even take my information for granted. See, it's just like a lot of people put out citations that somebody else wrote expecting it to be accurate, and then you find out later it's not. Now, your citation, though, was only half accurate on Cruden v. Neal. If you see where it does say what you said it says, okay, that every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Does it say that? Yes. But what you miss is in lots of court cases, they have a section that they will call synopsis. That's where they'll tell you the quote unquote facts of the case and what is being argued. Now the question is does the court agree with the argument? You scroll down here, there's the West head notes. There's your attorneys and law firms. Okay. Now, look at here. You didn't even go look at the opinion. The opinion is the ruling of the court. Okay. In the opinion, you don't see anything dealing with consent. Okay. So the question you have to ask is, what was the opinion of the court based on the relevant facts and the application of what was being argued? That's what you got to look at. You don't just pull something out of a court case just because it looks good and feels good to you and claim this is what they say, that gets us in trouble. Now, remember what I told you on Cruden v. Neal. You see what it says right there? Synopsis. Again, what does that tell you? What are the facts of the case and what is being argued? Okay. Then you got the procedural posture in this case, because this is actually an interesting case. This was about a section of law that was under question of was it a law? Their stipulation was that it wasn't. Okay. It doesn't say all laws. Nowhere in this case does it say all codes, statutes, rules, and regulations are not law. That's the famous citation. Nowhere. Okay. But the particular part that was being argued, that specific section in the code that they were arguing, this is actually a workers' comp case. And they were saying that specific section in the workers' comp, the way the legislature did it, they said it was not law. And the court agreed because the legislature did not follow the proper procedures under the Constitution when passing that act. Okay? But again, you have to go down to the opinion. This is where you get this opinion. From there tells you the ruling of the court. That's where we get these West key head notes. These are your head notes that goes into your West keys. Okay? Now, let's look at Rodriguez versus Donovan. Everywhere the phrase due process comes up. And you will not see that citation. Right here in the synopsis. He said he was deprived of due process. Now look right here. This is in the head note. Didn't see right there that he was denied due process given Secretary's failure to provide a hearing. So, see, things are not what people say they are sometimes. Now let's go on down. District Court was to exercise its discretion to determine whether claimant who challenged suspension of workers' compensation's benefits on due process grounds. Okay, let's keep going. He was claiming that under the workers' compensation law, he was denied due process, not under all the laws. Okay, let's go on. Right there, due process. Rodriguez's claim had violated the Fifth Amendment due process. Right there, said the conduct of the secretary that Rodriguez challenged in his action is not the allowing or denying of payment, but rather the manner which his claim was decided. He contends that he was denied due process. Okay, you see, this is the argument. The record before us indicates that Rodriguez may have cognizable due process claims. Rodriguez does not make a facial attack on the constitutionality of FECA. Okay? He's not challenging the law itself, he's just challenging the procedures. We don't mean by this to express any opinion on the ultimate merit of Rodriguez's due process claims. We defer to the district court in the first instance. We simply conclude that on the basis of the record before us, Rodriguez's due process contentions appear to be more than mere allegations. Failure to exhaust FECA remedies barred suit under the Federal Tort Claims Act, but we hold today that FECA was not intended to preclude jurisdiction over a due process challenge. Premature interference with agency process. Oh, look at there. That one don't even say due process. Look at that right there. Some of these policies are implicated here. In particular, review at this point may be premature, and the record, as it now stands, may be inadequate for judicial review of Rodriguez's due process claims. See, we go on and on. You don't see anywhere where this case says that all laws, codes, statutes, rules, regulations violate due process. That's what I'm saying. It doesn't say that. Now, to my buddy Crazy Mark, this is the case we talked about. And this case does say the codes are not law, and they explain why. Look at here. The Idaho Code is a compilation of laws, okay? The compilation of statutes in the Idaho Code is merely evidence of the laws enacted by the legislature as set forth in the Sessions laws. The Idaho Code is not the law, and the Code Commission has no legislative authority. That's why the Idaho Code is not law. Same reason certain parts of the U.S. Code are not law. Because why? It's not the statutes at large. It's not the actual laws that were passed. It's not that there's no such thing as laws. Okay, the question is who compiled the state code? And you can scroll down in the opinion, and the judge actually says it in the opinion too. Because why? The Idaho Code Commission does not have legislative authority. And anybody who wants to read the case in its entirety, they can. Just go look it up. It's an Idaho case. Okay? So obviously look right there. At the very bottom, it says, obviously, when a set of codes was enacted by the legislature as the general laws of the state of Idaho at the beginning of the legislative session, it would no longer contain all the current statutes, right? But you go on down, they say this in the case. The codes are not law, but it's not that there isn't a law. I keep saying this over and over. This is the problem. The Bible said in the last days people would be lawless. The King James Version says iniquity, because people don't understand.